The reason that we need to understand the doctrine of precedent is because it enables us to have a tool to ensure that we prevent appellable error, which is a lawyer's number one duty. How does the law know what to do in certain situations? So today I'm going to talk about a really important concept in the law called the Doctrine of Precedent, or stare decisis in Latin. And what stare decisis is the fact that under common law systems such as Australia, the law recognizes that there needs to be a principle that we can rely upon to make sure that we treat like things like, or similar cases similarly. And that's where the Doctrine of Precedent comes in. So what precedent is that whenever the court rules or interprets the law in a specific way, because remember, under a common law system, we're looking at statutory interpretation, which is the law written by Parliament and then interpreted through the lens of a judge. And so when a judge sentences someone, we'll take a very simple example. If you have two offenders who are exactly the same, who've done exactly the same things, we would consider it an injustice if offender A got 10 years in jail and offender B got 5 years in jail. That's not right. That's not okay. And so this principle of parity, which can be used in sentencing and does often come up in sentencing, is a much broader concept than that, because the common law principle of precedent acknowledges and understands that we must treat the same thing the same. And that's very important, because it's an injustice under our common law system to treat the same thing differently. So how do we keep track of precedent? Because it must be overwhelming. Well, as a lawyer, firstly, the way that you need to think about this is you have an obligation in your legal practice to stay on top of the law. And what that usually means is that you're going to spend a considerable amount of your day, your week, your month, learning about cases that relate to specific circumstances. A big part of my role as a lawyer, for example, is to make sure that I'm up to date on what the law says about a particular issue. And what I look for when I review my factual case is similarities between what happened in my matter and what happened in a previous matter. Obviously, the law sometimes changes. We take certain crimes more seriously or less seriously, and we have a different understanding of how the law needs to be interpreted as time goes on. But fundamentally, what we're looking for is ensuring that justice is preserved by the mechanism of keeping similar things similar. There's a whole range of legal tools you can use to figure this out. There's a huge databases that tell you whether or not what an offender got for a particular type of conduct, what the factual circumstances are. And there's also some pretty cool things called guideline judgments. Now, what a guideline judgment is, it's a judgment given by the court which allows us to interpret how a specific crime should be utilized. One of the key guideline judgments is for drink driving. For example, it explains to us what the requirements are, what the court has to look at when it's dealing with a drunk driver. There's also a guideline judgment, for example, for armed robbery, which tells us what the court has to look at. For example, if you're armed with a weapon or you're in company, it aggravates it. If it is somewhat spontaneous, not well planned, it decreases the criminality. All of these different factors and all of these different considerations mean that one of the key legal skills that a good lawyer needs to have is a mind that is capable of doing proper legal research. And proper legal research means that you have to have a willingness to kind of get into the mud and search out for doctrine or precedent that supports your position. Now, obviously, the best thing you can find is binding ratio decidendi. And as you may know, ratio decidendi is the legal reasoning and the legal principle that is extrapolated from the case. So what is the legal doctrine that we apply to all the law as derived from this particular authority? And there's also obiter dictum. Now, obiter dictum is what is the legal rationale, what is the legal thought process. It's not binding, but it allows us to get a glimpse into a judge's mind as to what they considered, why they considered it important, and more importantly, what value it can bring to us in our interpretation. Because as a lawyer, quite frankly, your opinion is irrelevant. The only thing that matters is what the court has previously held in relation to this particular topic. And so, doing a full circle back to the start, the reason that we need to understand the doctrine of precedent is because it enables us to have a tool to ensure that we prevent appellable error, which is a lawyer's number one duty. Because lawyers have different levels of duty. The number one duty is to prevent appellable error. You have a duty to the court, that's the highest duty. So that should give you a bit of an idea about how the doctrine of precedent works, gives you a bit of an idea of how we utilize it, particularly in litigation, and how you can better understand the value that it brings in keeping a long, stable legal system.